Justice and Artificial Intelligence, a reform that has become inevitable. Hello, I'm Charles-Henri, dissident columnist. For centuries, justice has relied on a simple idea: facts, rules of law, and human decisions made in conscience. Today, that model is under pressure. Not because judges are incompetent, not because lawyers are unnecessary, but because the legal world has become too complex for purely human means to manage alone. Laws multiply, case law expands, files grow thicker, delays increase, costs rise, appeals become routine. Civil, commercial, administrative, and social justice systems are operating at saturation point. This is not an ideological claim, it is a factual observation. The structural problem, not an individual one. The crisis of justice is not a moral failure. It is not a professional failure. It is a structural imbalance. Judges face overwhelming volumes of cases. Lawyers work under growing time and cost constraints. And citizens often face procedures that are long, expensive, and hard to understand. In this context, the quality of first-instance decisions becomes decisive. When case files are poorly structured, incomplete, or confused, the risk of factual error increases automatically. And when errors occur, the response is almost always the same: just appeal. But appeal is not neutral, it is not free, and it is not accessible to everyone. Artificial intelligence, a tool, not a judge. This leads to a central question. Can we still afford to do without intelligent assistance tools in a system that has become so complex? Artificial intelligence does not judge. It does not decide. It does not rule. It has no authority and no power of decision. What it can do is handle scale. It can organize thousands of pages, build clear factual timelines, detect inconsistencies, check coherence between facts, evidence, and arguments, and synthesize complex case files. These tools already exist. They are used by large law firms, by specialized legal professionals, and in certain institutional contexts. The real question is not whether AI exists in the legal world. The real question is, who has access to it? An inequality that has become unsustainable. Today, powerful actors have advanced analytical tools. Individuals, small businesses, and ordinary citizens often do not. This imbalance creates a silent rupture of equality before the law. Allowing litigants to use regulated AI tools does not weaken judicial authority. On the contrary, it strengthens it. Judges receive clearer files, more structured cases, more readable arguments. The decision remains human. Judicial sovereignty remains intact, but it is exercised on a stronger factual foundation. A change that benefits everyone. A justice system intelligently assisted means fewer material errors, fewer forced appeals, shorter delays, lower costs, greater transparency, and restored trust. For judges, it means time gained and better clarity. For lawyers, a return to strategy, defense, and advocacy. For citizens, fairer access to justice. For the state, substantial structural savings. A debate that must be open. Such a transformation cannot happen in silence, and it cannot be imposed by decree. It affects the balance of democracy itself. This is not an attack on justice. It is an attempt to help it evolve before it fractures under its own weight. Refusing intelligent assistance in a world that has become too complex is no longer neutral. It is already a political choice. Conclusion. Artificial intelligence will not replace human justice, but refusing to use it as an assistance tool means accepting opacity, inequality, and growing distrust. The question is no longer technological, it is democratic. More to come in the next chronicle.